This is Colin O'Keefe here for LXBN TV. Ride-sharing app Uber is changing the way the world gets around, but they're doing so while thriving in what is really a bit of a legal gray area. The big question, are their drivers actually employees or are they independent contractors, as Uber says? I'm joined to discuss it from Dallas by attorney Rob Radcliff of Weinstein Radcliff, author of the excellent blog Smooth Transitions. Rob, first off, what are the tests that come into play when it comes to determining an employee versus an independent contractor, and how do they apply to Uber? It sounds like things could be a little bit confusing here.
Sure, and to begin with, there's really no it's a case-by-case analysis for every situation. And obviously, Uber and Lyft, who's a competitor of Uber's, are kind of pushing the limits of this. But generally speaking, what you're looking at is what, in terms of the employer, if it's an employer, or in this case, just a company like Uber that the alleged independent contractors are working for, it's what right of control do they have over the work that's being done by their drivers. And control can work to and apply to a number of things, be it behavioral control in terms of how the drivers carry themselves about, to financial control in terms of how they are paid, and just basically what does this relationship look like. Now, the Uber case is pending in California. They have a little bit different approach, but it's mainly many of the same factors that you'll see if you just go on the IRS guidelines for what constitutes an employment relationship versus an independent relationship. And frankly, it's those factors and those issues that are driven by the IRS, because at first issue is, from a taxing standpoint, that any employer has to be concerned with is, am I failing to pay for appropriate payroll taxes? Now, in the Uber case, which is pending in California, basically the court there has said, well, we're going to let this go to a jury because Uber moved for summary judgment and said, hey, as a matter of law, we are not an employer, we are an independent contractor. Well, that motion was denied. And so now it's going to turn to kind of focusing on these particular factors, because the court has said that there are fact issues here related to Uber. Some of the things that they were looking at there were guidelines, or at least guidance provided by Uber to drivers in terms of how they would drive up to a particular customer, what type of music they would play, how they should dress, those types of things that kind of maybe create a fact issue, maybe at least according to the judge, and provide some guidance as to how these employees would act. But the Uber company is a long way from any death or destruction or anything like that, because as you read the pleadings, what's apparent is there's actually an arbitration clause in place for these particular employees that hasn't even been resolved, at least at this point. So I'm sure you'll see Uber try to enforce that arbitration clause, which, as you know, courts are very apt to enforce those in the employment context. We'll see what happens in California, a little bit different jurisdiction, but here in Texas, that would be something I would be concerned as if I was a plaintiff, and something I would be pushing if I was the lawyer representing Uber.
Absolutely. Arbitration clauses are, of course, very big nowadays and a huge factor when it comes to these type of cases. But, is there anything else that stands out when it comes to how the courts are treating Uber? Or, what happens if the courts do say that the drivers are employees? What type of things does that open Uber up to?
Well, the things that it opens up Uber up to is really a challenge to their business model. You've got to wonder, how can Uber make it financially? Just a guess, I don't know what their books look like, if they're ruled to be an employer of all of these folks. Now, this case is limited to the state of California, but there's been some internal documents filed by Uber, not even in this lawsuit, but just in terms of some analysis that they were doing that indicates that there's about 126,000 Uber drivers nationwide. Well, if those folks were supposed to be classified as contractors, forget the tax issues, but just look at the allegations in the California lawsuit. What they're saying there is, well, we should have insurance provided for us. We should have workers' comp covered, meaning if there's any work on the work injuries, that would be covered. Also, wear and tear to your vehicle, gasoline, I mean, it goes on and on. Now, for an individual defendant or an individual plaintiff, that's not that big of an issue in terms of money. But once you pull all of those claims together in a class action, that becomes very significant, and you could see that really impacting Uber's business model, which is probably why they're very concerned about the lawsuit.
Absolutely. You really have to wonder if it all works if they decide that Uber is an employee, because not only do you have to worry about what they're going to do with this large pool, but then they have to figure out what labor laws in different countries and cities and all different types of stuff they're going to have to comply with. So it's a very, very interesting very interesting lawsuit to watch there in California. But I imagine we're going to see these types of things play out all over the country and probably all over the world as well. So it's certainly worth watching going forward.
You're absolutely right.
Well, once again, that was Rob Radcliff, author of Smooth Transitions. Be sure to check out his blog. It's an excellent publication. It is at smoothtransitionslawblog.com. Thank you for joining me today, Rob.
You're welcome.